What types of criminal charges can be brought against you in the state of Illinois after defending yourself with your firearm, and what are the possible sentencing ranges for these charges? Dan McDermott here, McDermott Law Group. Not your typical attorneys, guys. Number one, aggravated assault with a deadly weapon. This is basically what's referred to as brandishing in many other states. An example of this is pulling out your firearm when you're being threatened and saying, you know what, if you continue threatening me, I will in fact use my firearm to defend myself. This can be charged as a Class A misdemeanor, and you could be looking up to 364 days in jail for doing this, although it is supervision eligible. Number two, reckless discharge of a firearm. Classic example of this is firing off a warning shot, either into the air or into the ground, and you can be looking at a possible sentencing range of between 1 and 3 years in prison, which you'd be serving 50% of. It is also probation eligible, but it is a Class 4 felony in the state of Illinois. Number three, aggravated discharge of a firearm. This is when you discharge your firearm, not necessarily at your attacker, but maybe in a general direction to warn your attacker to thwart off this attack from happening any further. And this is punishable between 4 and 15 years on the low end. There are different things that can aggravate it and make the sentencing range even greater, but between 4 and 15 years on the low end, and you're going to have to serve 85% of your sentence if in fact you have good time. Now, number four, attempt murder. This is labeled as a Class X felony. This is what you already know it is. When you're being charged with discharging your firearm at this person in an attempt to kill this person. The possible sentencing range begins at 6 to 30. There are different things which increase that sentence all the way to life imprisonment. And that's for an attempt murder in the state of Illinois. And finally, murder. Number five, murder, which is exactly what it sounds like. You shot and killed this person. Even though you're doing it in self-defense, you can and very often will get charged with murder for doing so. This carries a possible sentence of between 20 and 60 years in prison at 100% of the sentence that you have to serve. And based on whether or not, for example, if in fact you're the person that personally discharged this firearm that struck and killed this individual, you're looking at minimally 45 years to life, again being served at 100%. All after defending yourself with your firearm. Very often, judges are not listening to your theory on self-defense in the very beginning. When you're going through your PFA hearing to make a determination as to whether you're being released or detained until the time of your trial, these things are not being considered whether or not you're acting in self-defense. These are things that are sorted out during the course of your trial. So understand the types of charges and understand the types of sentencing ranges before getting involved in these situations. Knowledge is power. Hopefully this is helpful. Talk to you soon.